And get started. Now it's official. I'll call the special meeting of the Westport Island Planning Board to order, June 23rd, 2026 at 6:02 p.m. We have all but one member present. I sent an email to Nick and haven't heard back, so we'll get started. Thank you all for coming. Thank you to the members of the public. I think we have at least one person online. Mr.
Robert Bergdorf is online.
Bergdorf, welcome. The purpose of this meeting, as I explained in the agenda and in the email accompanying the agenda, was to first talk about the anticipated application from Verizon for the tower/antenna that we discussed briefly during the pre-application meeting. I've forgotten the date that we did that, but at our last meeting. It was, as a result of that meeting, it appeared to me that it would be helpful if we all had an opportunity to sit around the table and brainstorm a little bit about how we're going to proceed on the application, since at least for me, and I anticipate most of the board members, this will be a new issue for us, and we want to make sure we dot all the I's and cross all the T's and get it right. So that was the first reason for the meeting, and I shared with everybody three documents, two of which I shared with everybody two documents from MMA's information packets. One was entitled Ethics and Conflicts of Interest, and the second was entitled, I know it has something to do with communications, but the exact title is Telecommunications Facilities. So again, as the MMA document says in their own materials, this is not legal advice. We can't rely on it as legal advice, but it's a resource, and I thought it would be helpful for everybody to be familiar with those as we go forward. The second item that I placed on the agenda, and I think we'll have time to get to, but if we don't, we can continue the conversation, was a discussion of a relationship between the site plan review ordinance and the building code and shoreline zoning ordinance. And I put that on the agenda at April's request, because we've had some discussion about how the site plan review ordinance interfaces with the other ordinances. We have two applications pending, one with Ms. Bartlett and another with Ted Christie and his wife. We've already charted the course in both of those cases. I don't anticipate there's going to be any change in that course, but I thought it would be helpful to just talk about that generally. April had a conversation with one of the attorneys at MMA. I had a conversation with the same attorney, so thought it'd be helpful to the board to share that information as well. What is not on the agenda, to be absolutely clear, is a discussion or consideration of the site plan review application. Ms. Bartlett raised some issues about that. I had some back and forth with her on that I shared with you all, and she shared with us a couple of examples of applications from other towns. As you all will recall, April put in a lot of work on generating an application as well, and we kind of put that to the side as we were doing other things and for other reasons, but it appears to be an opportunity to talk about that. It really doesn't have any application, no pun intended, to Ms. Bartlett's pending application or Ted's application, because they've already made their application. They've complied with the statute or the ordinance as far as we were concerned, and there isn't anything more to say about that. With respect to the pending application or anticipated application from Verizon, my view is the same, that that application is being presented based upon what's in the ordinance, and a consideration of the town adopting a new application form just for site plan review applications really isn't going to apply there either. So we will have a conversation about the application issue I suggested in our July and August meetings, and see where that goes. But it won't have anything to do, that application issue won't have anything to do with the two matters that are already down the road a ways, and then the new matter that we anticipate being filed. And just a footnote to that, as you all know from the emails, we have received at least a digital copy of the application from Verizon for the tower. Some of you may have seen that, but we don't have a physical copy yet. So subject to getting advice from our attorney, my view of it at this point is that the application is not before us until we have the physical application and enough copies for everybody to start looking at it.
So is this a new application or is updated application from the last meeting?
So what we had at the last meeting was the pre-application
Right.
materials, and
Which
that,
we've gotten, yeah, we've got that.
and you all have seen that.
Yeah.
That has the maps.
So something new has come in?
This is the formal
Okay,
application, not the pre-application
okay,
materials, but this, what they're sending to us is the formal application. Entitled the final site plan application and the requirements. So the reason when that arrives is important
of course, yeah.
is because the time frames kick in. You know, we have, I think it's 30 days. The first time period is 30 days to respond to the applicant with a decision as to whether or not the application is complete. And so we're going to kind of talk about that a little bit and making our plans for what comes next. When I say
We do
talk,
that tonight? Or next month, or?
what we're talking about is the timetables under the ordinance. So what we're going to be looking at is how the process is going to flow under the ordinance, following those time plans. So it's kind of an orientation as to what's coming next, so that everybody will be ready when the application does finally come in and we can start working on it. Okay. All right. So first things first, what I want to do is touch very quickly on the ethics issues. As I think I shared with folks, or if I didn't, I should have. It's clear that the Verizon applicant is going to be very aggressive in presenting the application, and we need to make sure we're doing everything correctly. As I say, dotting the I's and crossing the T's. I learned literally just as I was on my way here that Mr. Bergdorf has called our attorney And I have no idea what was said in that conversation. We have not had any contact from our attorney. And I'm anticipating that there'll be an opportunity to do that in the future. But there's at least some indication, as I say, they're going to be very aggressive, as they should, in representing their client about making sure that we're doing exactly what we need to be doing and how we do it. So, the first concern is, are there any conflicts of interest? I shared again that information packet from MMA. Hopefully you all have had a chance to look at it. But what I thought it would be helpful to do is just kind of review some of the basic principles of that, and make sure everyone has got that in mind and had a chance to think about it and make decisions. The first point that I see from the materials and just from my general experience is that this is something each of us has to consider on an individual basis, given the context and the facts, the nature of the application. We had a robust conversation during the pre-application meeting, there's some strong feelings already expressed within the community about this issue. First of all, it's a personal evaluation, and if anyone wants to talk it through or talk about it, we can do that here. We're not making any decisions. The board isn't making any decisions. This is purely an informational brainstorming. But it's important that we be very thoughtful and deliberate about how we handle it. So,
Is there a bylaw element or provision about conflict of interest? Because most planning boards have a little bit of a minimalist conflict of interest clause that we should be using for every application that we're looking at. So what's the status of our planning boards?
Yeah, the bylaw does address it briefly.
Because it's not just the one we're looking at now.
Are you pulling it up? No, let me pull it up. I'll pull
I
it
was
up.
gonna pull something else up, but I can pull that.
You can-
Fix agreement that I think we all signed as planning board members that goes over conflict.
Sounds good. That's sometimes, yeah, okay.
All right, let me pull up
Familiar, brother.
find the bylaw here real quick.
Yeah, I'm just curious about where we are right now with our ethics, which I think is generally good. Yeah.
Okay, I have bylaws up.
Oh, okay. I do too. See who gets to it first.
You do that, then I'll do the other one.
And then also the button.
Yeah, Jeff, you-
So you could,
But do you have,
that's the planning board bylaws.
no, that's what I'm looking at.
Yeah,
Well,
so you've got it.
What we're looking for is the reference to conflicts of interest.
Okay.
And you're saying we all signed something.
We all signed the ethics agreement. I could read the ethics agreement
Yeah, go ahead.
section on conflicts of interest. No town official shall advocate in any public meeting or in his, her official capacity on any matter in which that town official has a financial or personal interest, or where there is any appearance of conflict, except upon full and timely disclosure of that interest. No town official may participate directly or indirectly in the selection, award, or administration of contracts, procurement of municipal assets or services, or the forgiveness or abatement of property taxes or penalties, if he or she has a real or apparent conflict of interest. A real or apparent conflict exists when any of the following parties has a financial or other interest in or receives a tangible personal benefit from such financial decision. The town official involved in the selection, award, or administration of a contract, any member of his or her immediate family, his or her partner, or an organization which employs or is about to employ any of these parties. Any town official with an actual, apparent, or potential conflict of interest as defined in this policy shall attempt to avoid the appearance of a conflict of interest by disclosure or by abstention from decision-making. Disclosure shall be reported to the chair of the select board, or in the case of an elected board member, disclosed at a duly noticed board meeting. In the case of funds received from federal or state grants, any such conflict shall be disclosed in writing to the federal award agency or pass-through entity in accordance with applicable awarding agency policy.
Thank you. Good, that's good.
Very good.
That covers a lot of ground.
So we've all signed that.
Yes.
We've all signed it. Yeah.
So, and I can read
Go ahead.
the bylaws. So the planning board's bylaws, Article 7 voting, and it's on page 4 of the bylaws, says if a member has a conflict of interest, that member shall recuse himself and shall not be counted by the membership in establishing the quorum. The first alternate, if available, alternatively, the second alternate shall be asked to act as a member of the board for that matter under consideration.
Well, it says himself, so I guess it doesn't apply to me.
Well, this is.
All right, very good. Anybody have any questions about what we've just read? I don't, April, if you might send that, what you just read to everybody, just so they can have it in front of them. Again, you don't need to make any decisions tonight. This is just increasing everyone's awareness and sensitivity. Yeah.
Would it establish that this planning board has a decent conflict of interest provision? And we don't need to add more to it? You know, we have a decent, we've gone through a process, we've all signed something and we've all looked at the planning board bylaws, so what
Yeah.
else is there to do for us to?
Oh, no, yeah, the only reason for raising it is for everyone to be aware of it.
Okay,
And
just wanted, okay.
if, for example, after thinking about it and hearing the definitions, you feel uncomfortable and that you might have a conflict of interest, then that's something that you might want to resolve before you go further. Because here's the point, right? If we start doing things and making decisions as a board and Verizon doesn't like the result, they sue us. One issue that they could raise is that the board members or some portion of the board had a conflict of interest, and that would potentially invalidate our decisions. So we have to be thoughtful and careful about it.
And it applies not just to.
Hold on.
I'm sorry.
We'll go. April, go ahead.
I'm eager to recuse myself from this matter. I live too close and I have passionate feelings about it, as you all heard at the last meeting, and I just would feel ethically better to step back from it at this point. And I hope that doesn't cause inconvenience as the first alternate with our second alternate absent, but I think it's for me, the right thing to do.
Okay, all right, very good. Obviously, what we're going to be talking about is general and generic, but when we're talking about the preparing for the Verizon application, then we won't have the benefit of April's input and votes if her vote was necessary, if we didn't have a quorum. Okay, April, thank you. Dick, go ahead.
Suppose we get into a determination on this and we discover that there is a conflict, can we step aside at that point?
Yeah, if at any point in time you feel like you have a conflict, you need to do something about that. But obviously the point of having this conversation now is so that we don't get down the road and all of a sudden light bulb goes off and what has transpired up to that point might be compromised. So
I'm just thinking before this clock starts, we need to review this particular information package that.
yeah, and think about where you are, where each of us is personally with respect to the application.
Right.
So, for example, if any of you have stock in Verizon or have family members who are employed by Verizon, this would be a good time to think about that.
It also applies to any application that's coming before us.
Yeah, oh, yeah, yeah, it doesn't just
It's not
apply to
just
this.
ours, it's
No, 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 no,
anything
no.
that's coming before
No,
us.
absolutely, absolutely. Go
You
ahead.
want to say something?
Well, I'll wait. I do want to speak, but go ahead.
You had your hand raised first.
Okay, well, I just wanted to note that this is an interesting, this particular application is interesting because 5 of us are in some way referenced or in the sphere of the application, that we live within the range or have property within the range that they're considering locating the facility.
Okay.
So that makes it a bit more unusual that we would all have this input, connection. Not that it necessarily would preclude us from saying, it's really a conflict of interest, but it does mean being mindful, I think, of this particular complexity in presenting and where this might go in terms of their application.
Yeah. Well, I think it's important to, as I say, reflect on it and make a decision individually. Be mindful, and this point was also made in the MMA packet. One could make the argument that everybody on the island could have to recuse himself if they were going to benefit. And one of the points that's made in the MMA materials, and I've encountered this in other contexts before, is if you exercise or if you apply the conflict of interest rules to your situation, and it eliminates so many people off the board that you can't have a quorum, then that's an exception to the rule. You have to have a quorum. So we have to have a planning board. We can't all be excused because we're simply on the island and we may receive the benefit of the telephone service.
Just in the past, when there has been refusals, it was direct abutters, and that's been pretty obvious. But as far as someone, recusing themselves outside of that, I don't know in the last 4 or 5 years that we've had that, so it'd be a first. Just coming from the history standpoint of the board, we've had, I think it was like Joanna once had to recuse herself. With her abutter.
They were butters, yeah.
Right. So that's just been the history. And then as far as my question is, once the voting party of the board is established, the other members of the board, are they then participating as members of the board, or are they participating as public?
Yeah, if somebody's recused, like April, yeah, she would, at that point, take a seat in the audience and participate just as a resident.
Including this meeting?
As I said before, when we're talking in this study session about the Verizon application, and we're going to talk about it here in a minute in terms of just the general orientation, she would not be able to participate. And this isn't a public hearing, so unless we have specific questions from members of the public, we're probably not going to have general public comment. So she would just have to be quiet.
My objective with recusing from the board is not to participate as a public member now or in the future. I just want to recuse.
Yeah, I mean, you can certainly participate as a citizen, but that's up to you.
Right.
Yeah, and with respect to the abutters, technically abutters are parties in interest. They're going to be on the mailing list and of official or formal parties in the proceedings. So I think that would be a cause for concern.
One of my other questions is, I was overviewing our minutes. And as posted, they don't seem to have attachments. So we frequently look at exhibits during the meetings, so any exhibits that are, or documents that are viewed or presented during the meeting should be attached. It might be a technical part, but.
No,
think-
I will work on it.
We can do
Okay.
that, we can- yeah.
Yep. I'll add it to the list. Hold on. Thank you.
The. I obviously going over the application, I am within 1,000 foot radius, so it'd be notified. By certified mail, so I don't know if that technically counts me as an abutter. I'm an interested party as a part of the planning board, but I could further review that with you, John.
Yeah, I mean, I think, based on what you've described, I think you're in an area where, you'd have to do some, serious thinking about that.
Yeah.
And then because, keep them,
Definitely, I do not want to put the town or the board or their decision at risk. So if there's any danger of that, put it to the chair to make the decision of that.
well, wouldn't be my decision. It would be, I mean, if it came to making a decision, it would be a board decision, but first and foremost, it's a individual, decision.
Okay.
And, but if you have questions, I'm certainly happy to talk to you about it, or you can talk to others about it. But you've really hit the nail on the head, right? The whole principle behind, or the whole foundation behind, conflict of interest rule is to make sure that, any proceedings, any official proceedings, have the full integrity of, the law, that's embodied in the ordinances, as well as, the confidence of the community. And if, you hear the appearance of proprietary, and that again is discussed in the MMA materials too. It's interesting under Maine law, it's a very narrow legal definition. There has to be some financial
Yeah.
interest.
And how's that proven until there's like an assessment?
Well, I mean, we don't want to get into it. Could it be proven if, because then you're talking about taking the witness stand and discovery and that sort of thing. So again, with respect to the MMA materials, they start there as a financial interest. Then they, talk about, and that's the statute. The next layer of analysis is what's the case law? And the case law in Maine is, starts getting into that more general category, the kind of squishy layer is there's, and ultimately, when you boil it all down, if somebody looking at it from the outside, for example, if Donna or Bailey were looking at, would they be concerned about the appearance of impropriety, appearance of bias, appearance. So, as you say, the safest course is not to get close to that third rail. You don't want to have to defend that in court. If you're close, the general rule is, don't go there. So, but, again, we're not making any decisions tonight on Naples. We've thought about it, apparently, and made a decision, and that's fine, but I'm not putting anybody on the spot.
I wasn't thinking of it much in Ireland.
The goal is not, or the object is not to put folks on the spot. It's just to raise the consciousness, make sure everybody thinks about it and makes a good decision. Yeah.
So I got a question about the functionality of the board. From a technological aspect on this, when I was looking at the MMA packet on telecommunication facilities.
Okay, let's draw a line. Are we all done talking about conflict of interest?
Yes.
Okay,
Yeah.
let's talk about telecommunications. Go
Okay.
ahead. Sorry to interrupt.
Sit in the audience for this? Should I sit in the audience, or is it okay?
We're not reviewing the application.
Okay.
So when I look at that information that MMA gave us in that packet. We have options if one technology is presented, but our options are limited if a different technology is presented. So I can't evaluate that at this point in time because I haven't looked at the final application.
Right.
And so I'm saying, if we look at that final application, I see our options are limited. How do we handle it at that point?
Yeah, so that, I mean, that's a good question, and you know, it raises the opportunity, which is in our ordinance, and I think we're just generally familiar with it, is if we need expert advice, then we ask the town to fund obtaining an expert. And you know, it may very well be that once we receive the application, have a chance to look at it, that we need to do that. And the ordinance also provides for an opportunity to assess the cost of the expert to the applicant. You know, there's a process for doing that. So yeah, if we as a board feel we need expert advice, and this, you know, sounds like it might go there, but we're not making any decisions yet. But if it does, then yeah, we certainly have that opportunity. And not only the advice of an expert, but given the most recent development with Mr. Bergdorf contacting our attorney, we're already spending money on the attorney, and we didn't even decide to do that. Because when Mr. Bergdorf calls him, he's not going to do it for free. He's going to send us a bill. So we're off to the races, and that's fine. I mean, every applicant needs to do everything they should in order to represent their interests and get from point A to point B. Our goal as the board, obviously, is to do our job in applying the ordinances, dot the i's, cross the t's, make sure it's fair for everybody, and very importantly, make sure our residents have full opportunity to participate and are aware of what's going on, which we'll obviously do in this case as we do in every case.
Second question.
Yes, sir.
In the same vein, if we wish to add some technology or have some technology removed, and we won't know until we get into this process, we have that option.
Yeah, I'm not sure what you're thinking there, but are you talking about the other antenna that's there?
I'm talking about adding on a second antenna to allow us to have more communication.
Oh, yeah. Yeah, it's all part of the same mix. I mean, you know, as we have questions regarding anything technology related, yeah, we at least have an opportunity to ask for resources there from the town to spend money to get expert advice. Okay, good. Since we're talking about the telecommunications information packet, anything else there that folks caught their eye or raised any questions about? And then we'll talk about the process, you know, how we see the process going forward. Go ahead.
The guidance does reference the type of technology being proposed, and with different standards for periods of time for review, depending upon the type of technology or the size of the installation, whether it's a new tower or whether it's a co-located. So some of that, hopefully we'll expect that to be clear in any application that we get, just what those factors are, since they do seem to be relevant in making a decision about the application.
Yeah, and that, you know, that's a nice introduction to talk about the process, because as I understand it under our ordinance, our first decision is to determine what criteria under the ordinance apply. The applicant has an opportunity to share with us their position on what criteria they have to comply with and what criteria don't apply. we had that discussion in the context of Ms. Bartlett's application a little bit. So, you know, first consideration is which criteria apply, and then is the application that has been presented to us complete? And, you know, we go down the list and say, well, number one, do we need this information? And number two, is what we have sufficient for us to evaluate the application of that particular criteria? So I anticipate we're going to spend some time doing that once we get the application and have a chance to go through it. You know, I referenced it's 139 pages. From what I saw that April shared with me, I haven't, you know, I've only gotten into it about 3 or 4 pages, so, so we'll have some work to do. But keep in mind, there's a clock ticking. You know, we've got 30 days to make that first decision once we get the application, and that, you know, 30 days will go pretty quickly. So, you know, while we're on that point, what I'm thinking, and again, we're not making any decisions here tonight. We can start doing that at our meeting in a couple weeks. But what I'm thinking is, as you read through sections 5 and 6, and I guess even 7, you know, look closely at the timelines there and what we have to do within those time periods, and we should be prepared to make some decisions, not only to educate ourselves, but educate the public and the applicant as to what's coming next, each step of the way. One thing that's kind of percolating through my mind is, you know, we talked about having a lot of public hearings because there seemed to be some interest. And I jokingly said, well, we could have 20 if we needed to. I don't think we have time for 20 in 30 days, but we might have time for more than one. And, you know, if we have 2 or more, that's, you know, that's up to the board. But at any rate, I think we need to make sure the public has an opportunity to be included at every step of the way. So I would anticipate having a public hearing, at least one public hearing, between the time that we get the final application, assuming that's in 2 weeks, between that time and the 30-day clock. So that would be 1 or 2 public hearings on the application, and, you know, within the next month. And the issue on the table at that time is the application complete? So, you know, we'd be hearing from the public, you know, what information do they think is required under the ordinance that we don't have, that we didn't think about, and that could very easily or very quickly include a need to get an expert, you know, going to what you raised. So be thinking about that. Again, I've been on the board for 5 years, I guess, and we've never had an application for an antenna. So I'm not going to bring any experience based upon those 5 years. I do have experience the last 50 years in planning boards, but not here. So at any rate, so I think that's our first step. The second time period that kicks in after we make a decision for the applicant as to whether or not the application is complete, is set forth in more detail under section 7.
Of the site plan ordinance.
Yes, I'm sorry, the site plan review ordinance, section 7. Um, once once we decide the application is complete, then we have 30 days to decide whether or not the application should be approved. So there's another 30-day period of time, another 30-day period of time to have at least one, if not more, public hearings, depending upon what the board decides. Yeah, that's just, kind of the gross 50,000 foot.
And you've mentioned
Yeah.
a couple public hearings, mostly in respect to the Verizon application as opposed to any application or?
This would apply to any application, but
Okay, cool.
we're focusing in on the Verizon application because it's imminent.
Oh, no, absolutely. It's complicated. It's complicated. Absolutely.
Yeah.
Yep.
And
Regarding, there has to be public notice.
yep, there's a whole provision. for
Yeah,
that.
and then beyond the abutters being sent certified mail or physical proof that they
Yeah,
have received, yeah.
Yeah, I have every confidence that Verizon is gonna be on top of that and be doing exactly what the ordinance says they need to do.
Can I speak to the general process here?
Absolutely.
Two things. I think the applicant pays for experts. There's a little bit in the site plan review ordinance. I won't be able to cite you chapter and verse, but
Okay.
I think if the planning board wants an expert, there would be an escrow set up for the applicant up to a certain amount, which the select board recently set. It's on our fee schedule.
We're not gonna hold the select board to that tonight.
Yep,
What?
but the applicant would pay that amount if necessary. The second thing is on public notification. So that's getting published in a newspaper of record twice before the hearing. So the 8th is not the hearing. The 8th is the hearing on Bailey and Ted. So that has been sent to the newspaper and will be published a couple times. The notice on these things is a little weird in the sense that, what was it? You don't actually have to notify, the applicant has to notify abutters that they are a party to the proceeding, and that is literally it, which I think is not enough. That's what's in our ordinance. So I guess I just bring it up, don't rely on the applicants, that's their only obligation. So I think as the planning board, we should go further and make sure the public knows about the hearings and the, what the hearing, obviously, but also the site visits, that kind of thing. Specifically, not just general public notice, because who's gonna read it in the fine print of the newspaper?
Yeah, and that's what we've done. Every opportunity we've had, I know, there've been a couple applicants who were a little concerned that we were going above and beyond and reaching out to applicants who had expressed an interest beyond just being abutters. So we will do everything we can to do more than we need to in terms of notice and including public, make sure everybody's up to speed on it. Okay. Any other questions or thoughts or concerns generally about the process we're going to follow? And again, this is just the beginning, so we're not making any decisions, but I just want to brainstorm a little bit.
Yeah, I want to carefully separate this from the process discussions, because I'm really keen to talk to the board about how we handle site plan review. So I'm kind of sitting on my hands here wanting to talk, but I don't want to mix it in with the Verizon discussion. I wanted to mention about hearings, so it's sort of laid out in the ordinance, you do this, and then you do this, and then you do this, and you do this. How do we justify additional hearings, I guess? Is there a place where we can add those in? Cause I don't know.
Yeah.
If there is.
And again, once we talk to our attorney, they may have an opinion about this, but my view of it, as we're brainstorming just here is that we can have as many hearings as we want to. We have to have it, well, I say we have to, I think it's even discretionary under the ordinance as to whether we have a, well, no, that's the site review. Yeah, no, we have to have at least one hearing. But I don't think there's anything that says we can't have more hearings. And I suppose we could call a hearing and continue a hearing. But,
Yeah, I guess just in a general sense, like, if I'm an applicant, I want to be able to rely on what's written in the ordinance and know that's what's gonna happen, and so it makes me worry in a general sense, if we're trying to write up the guidance for how applicants should approach this, what to expect, if we're gonna be calling additional hearings, that's something we want to be clear about. We can do that at X, Y, and Z points, and you should expect it. But in my initial read through, I didn't see anything like that, so that's why it kind of gives me pause.
that's something we can ask the attorney. All right, Dick.
Another consideration is this application is more complex than setting a pier that we usually tend to deal with. And so I'm wondering if we need to, if we can have sessions that kind of open to the public to just understand more of the fundamentals of this.
Well, I mean, my view of that is, I want to have a conversation about doing that for the next 12 months. We've got a lot on our plate with respect to potential amendments to the ordinances, everything we've been working on for the last year. So I have in my mind proposing to the group having at least 2, maybe as many as 3 town meetings, may only get 5 people, but at least town meetings to start talking about our land use ordinances, how they work, and why we're proposing what we're proposing, so that we get everybody up to speed. I know it. It took me a couple of years to figure out that, what we call the building code really isn't building code. It's a zoning ordinance, and then how the shoreline zoning ordinance interfaces with the building code, and then the site plan review. So, I have experiences in other jurisdictions with these things, but every jurisdiction is different.
So John, you didn't mean town meetings, you meant community meetings.
Sorry.
Did you mean town meetings or community meetings? You didn't mean formal town meetings.
Well, not a
Did you?
form, not a,
He referred to it as
I wanna keep Donna busy, but not that.
Shaking her head
He referred
Not
to
a-
it as a hearing.
yeah,
I heard town meeting, I translated that to a community
Yeah.
informational.
yes,
Oh,
I
okay,
apologize.
No, we are listening now.
Yeah.
All good, it's all good, all good. So I just.
A
wanna be
meeting
clear.
open to anybody and
I just
everybody
wanna Be clear about it, yeah.
in the town.
We're on you, we're on you.
So, anyway, but so I think that's something that, generally, is a good idea, and something that we can do to advance the level of understanding, in the community about how all this works. Because it was an education for me when I first started. All right, okay, any other general thoughts you want to, so right now I anticipate, we will have the final application, hard copy at our meeting, in a couple of weeks.
Okay,
July 8th, I guess it is. And, we'll set our schedule from there.
okay,
But, in setting the schedule, again, call your attention to sections 5, 6, 7. So that we'll all be on the same page. Okay. All right, good. Anything else? Oh, on the telecommunications, I just wanted to share with you all, just spent a little time, I was trying to figure out how many towers we had on the island and where other towers would be, and I found this website, antennasearch.com. It wasn't easy to find these, but anyway, I did, and so I pass these around.
what was that mean?
It's the dots. There's a legend over on the left-hand side that identifies where the dots are, but
Holy moly.
long and short of it, as far as I could tell. Should be not very late. For the audience, this is what it looks like. It's not very impressive, but that's what it is.
Mhm.
As far as I could tell, the dots at the north middle of the island are the firehouse station. Then I think the Cromwells have something that's probably a radio antenna or something, but it was identified in the legend as belonging to the Cromwells for their business. And then there's one other that I don't remember what it is, and then the two dots at the southern portion of the island are is the area where this application is being proposed. So, sorry, I was just curious and thought I'd share
Oh,
that.
good idea, good idea.
That dot above the two dots, that's on Bailey's property, which was the Cromwells.
Oh, okay, okay. All right, good. So yeah, so one of the issues that we talked about at the pre-application meeting was the tower that's there now. What's going to happen to that? Is it a tower that could be used for this purpose? So, we'll have more conversation about that. Perhaps beginning on the 8th. See how far we get with it. Okay. All right. Is there anything else about the telecommunication information packet that caught anyone's attention? If you haven't looked at it, again, it's not the gospel, it's not the end of the conversation, it's not legal advice, it's just a kind of a beginning orientation.
The attachment didn't come through for me. For some reason, the attachment didn't come through to me. Is it something that's readily available on the MMA website, or is it?
It is.
Okay, I just went on
I
there.
went there directly and
I think
it's under one of their, they have sections in the site with,
would she need to have a login? Do
Yes.
you have
It could
access?
be logged
But
in
she
as a
should be,
member.
I don't have a login for MMA.
and then you tell us what to do.
All right, well, I can send it to you.
I
I'll
can send
send
it to you as a PDF, Debbie.
Okay, good.
When is that?
one from everyone.
I think I don't have it either.
Thank you.
Well,
Uh-huh.
John said on two documents, and you're talking about the telecommunications
Yeah.
document.
Just that one.
And when I actually
Okay,
went
all right,
to open on, I didn't happen the first time. I had to close and reopen Word, and then I got the right document. For some reason, it was giving me two versions of the conflict of interest.
Yeah, I was just trying to find it on the website, but I think it's something you have to be logged in as a member for, so I don't have a member login.
Okay,
You can
You
have.
can request.
we can make,
Yes,
we
That'd
can,
be great.
we can make
I have a
that
copy of it right here in my computer. I'll give it to you now.
one,
We have it covered.
one reason I wanted to share that with you all was, during the discussion that we had at the pre-application meeting, Verizon's attorney, repeated, many times, the preemption argument. And this, again, it's not the final word. We can, rely on our attorney, and I don't know whether he has expertise in telecommunications law or not, but, we can certainly find someone who does. And that, that will be the legal advice we rely upon. But at any rate, what this information packet did was give you just kind of a running start orientation as to that issue. It's there's more to it than that.
Yeah, it was a law in 1996, right? That was passed in act in 1996 that he was referring to.
Yeah, there's a federal statute that applies, but the land use law that establishes the authority to do what we do in enacting ordinances and applying the ordinances still carries a significant amount of weight. And the preemption is a fairly narrow area. And that's my read on it. So again, we'll rely on the attorney once we get to that point. At any rate, point is, there's more to the story than what we heard from Verizon pre-application meeting.
So I wanna kind of back up and ask a kind of a general question. But first, kind of going over the timelines or the steps in our process with site plan review. And that I think April is kind of summarizing the steps. But from the ordinance, you have to, in 30 days, you're supposed to review whether the application is complete. Then 30 days, within 30 days of that, we're supposed to have a hearing, which could include a site visit. And then within 30 days of the hearing, we're supposed to complete and provide an order, either approving or disapproving with an explanation.
Mhm.
So those are the basic timelines for site plan review. And I would think this application, we would want, the telecommunications application, we'd want to follow that as well, if possible. It's the indication here is that because of the technology, there may be different timelines if we require more time. But that's kind of like the basic time to review the application would be a month to see if it's complete, a month to have the hearing after we get the complete application, and then a month to make a decision. And that's the base from which we then diverge if we have to.
Yeah, it's spelled out in section 6 and 7, so that's what we're gonna follow.
Yep.
Yeah, I don't want anyone to get sideways and think that any time frames that are described in that telecommunications packet apply. Our Bible on that is the ordinance and the timing sequences that are set forth there is what we're gonna follow. So that's our job.
And maybe just another question, just as we look forward to reviewing this, and not just for this application, but any what we might have for telecommunications. What other considerations do we have that we should be looking for? Is there anything special for completeness that's related to telecommunications, or is it simply have they provided all the elements in the ordinance?
Yeah, I think that's what we want to be thinking about when we decide which criteria apply and in defining what is included in those criteria. That's our list.
Yeah.
You're saying that once we have the complete application in hand, that is when we start applying the criteria in our ordinance and start.
See if it addresses
Yeah.
the criteria.
Yeah, that's, again, to emphasize, the first issue is, number one, are there criteria that don't apply? And the applicant can come to us and say, I don't think I should have to provide any information on this or provide any information on that.
They don't need the traffic analysis of the number of vehicle miles.
Perfect example. And once everybody's clear about which criteria apply, then we decide whether or not the application is complete and we have, hold on, guys.
Sorry.
No, that's all right. Well, the second thing we do is decide whether or not the information that we have in the application is complete enough to allow us to do our job, which is applying those criteria. So if there's something missing, we let them know. We can deny the application because at that point, because it's not complete, not deny the application, but find that it's not complete. And then the applicant has time to fill in blanks that we think are missing. And again, it's, keep in mind there are towns that have a specific ordinance that deals with towers and antenna, telecommunication towers and antenna. We don't have that. So what we're applying is the site plan review ordinance, which does apply according to the language of the ordinance.
In section 10 under criteria, 10A10, it lists that it needs to conform to basically all of our other ordinances. So do we know what other ordinances would be?
You're going to, as a board member, you're going to
We're gonna be.
tell us.
Okay,
Looking at that, okay.
yeah.
Yeah.
Yikes.
Yeah, so this, we've got some work to do, folks. Yeah, so, this is what we do. Not one of us took a test on whether or not we'd read everything, from beginning to end. But,
Reading 139 pages is gonna be fun.
It's a pass-fail kind of thing, so.
right. Okay, all right, we're pushing the time envelope. I was gonna try to keep this to an hour, and we're at the hour mark. You all wanna continue and have a conversation about the site plan review ordinance and how it interfaces with the building code and shoreline zone a little bit. I know April does.
And the comprehensive plan is under there as well.
Well, yeah, I mean, that's, that's there. The comprehensive plan is, I guess, the beginning Bible.
I have a
But-
very specific concern in question, I guess, that I'm
All
not
right.
sure if we can.
Well,
answer.
Let's do it.
let's,
Yeah.
I think we're ready to do that. Why don't we, see if we can, do it, have this conversation, and we're not making any final decisions, and we're just brainstorming about it, but
Yeah.
it'll take, 30 minutes or so to kick it around a little bit. April, go ahead.
Okay. So the particular situation that brought this up for me is Ted's peer permit / site plan review application. I was a little confused by how we should handle that. And at the last meeting, I kind of made a case, and I thought we kind of had agreement, we would just treat it as a peer permit application. Because he did do site plan review back in December. He mentioned the pier in there. He did not provide a lot of information on it. He didn't provide pictures and the sort of things that you usually want in a site plan review, but the board did accept it as a site plan review, and he did mention the pier. So when he submitted that paperwork, I was a little confused, like, do we really want to go through this 30-day thing with all these, all this time? Or we could just treat it as a peer permit application, which we also handle, but which we could get done within 1 month. The select board do their review, the planning board can do their review, sign off on it. So I thought we had kind of agreed on that, and then we all left, and I have this packet with $100 check from Ted. So that presented me with a practical issue, which is, well, if it's a peer permit application, the fee is $175. Site plan review fee is $100. So I came back to John and I said, what do I do? Do you want to talk to Ted? Should we ask him for the $75? How do we? I kind of figured it was John's position to do that. And John came back and said, well, I think we are going to treat it as site plan review. And I said, oh, okay, we're going to treat it as site plan review. I mean, my concern with that for Ted is that he has this much longer timeline. And the way, at least I had understood it up to this point, is you do site plan review, you pay your site plan review fee. The planning board does this sort of global look at your project to see if it fits with the community based on the criteria in the ordinance, makes a decision, and then you go get your permits individually through Gary, or occasionally through the planning board if it happens to be the kind of permit that we handle. So I was like, Ted's gonna have to do this longer timeline, and he's gonna pay the 100, and then he has to pay the 175 again and come back to us again for a peer permit application. And it's kind of redundant because he's presented to us as a flycatcher application, like a peer permit application. So I feel like this process is getting a little muddled between site plan review and permit applications. And what John and I have been going back and forth about, and I went to the MMA to try to figure out and get some clarity on, is what is site plan review? Is it in any sense permitting? Or is it something else? In my mind, it's an underlying condition, and then the applicants go get their permits, which is actually what I told Bailey before I knew there was any confusion about this. And so I want us as a board to be extremely clear on that. And I don't know who's right or wrong here. The MMA confirmed my understanding, but then John's had separate conversations, and I want us, as we go forward with these 3 applications and in the future, to really make sure we're all on the same page about what site plan is and how it interacts with permitting.
Yeah, yeah, and I think we're really on the same page more than it may sound, because just to put it in the context, conceptually in the context, and I confirmed this when I talked to the MMA attorney. The site plan review process is basically a subset of the permitting process. Doing the site plan review does not equal a permit. It's one of the layers of things that happens to qualify for a permit. What got this all gunked up, and April has been, been very strong about this, and this, from my perspective, was really the issue. And that was, April was concerned that we didn't have a site plan review for the entire project all at the same time. That when Ted first came to us, she felt we should have had comprehensive application site plan review at that point. And I addressed this directly with the attorney, and he said, yeah, that would be nice, but they don't have to, right? And the risk, as we've talked about it in Ted's case, is the risk is if you balkanize it, if you chop it up, as he did,
Yep.
which he can do, if you balkanize it like that, there's a risk that one piece of his puzzle may not be approved, or that he has to pay more to do it, or it's going to take more time, as opposed to doing it all at once. My recollection of the history there was that Ted started with a residential or the LPC zone.
CFMA.
Yeah. And it wasn't CFMA, that came later. So while it was still the residential slash
Limited residential commercial.
limited residential, he made an application to make improvements, which didn't come before us, it went to Gary. So so there was no site plan review associated with that. It wasn't required. Then the next thing that happens is he applies for the CFMA for the entire parcel, which included what he had already had permitted and appropriately done. And again, April appropriately raised, well, why are we doing this piecemeal? It would be nice to get it all done at once. And the answer is, again, as I confirmed with the attorney, that would be nice, but you don't have to, right? You can chop it up if you want to.
I just don't know if Ted fully understands how much harder he's making it on himself. And I would like us to be really clear about that. I think.
Let me finish and
Yeah.
because I think we get to the same point. And that is, in the future, I mean, the horse has already left that barn. In the future, when someone comes to us with a application for CFMA, and this would require a change for the ordinances, but I think it'd be worthwhile to put in the ordinances, even though we only get these things once every 10 years. But we spent way too much time talking about it in this case. Is when we get the CFMA application, we require some plan for that.
But they're two totally separate things.
Oh.
We shouldn't confuse those either.
Well,
CFMA, site plan review, permitting.
but you're equating them and they're not equal. The
No.
site plan review, it's like, if we were in the context of a subdivision application, you would have the equivalent of a site plan review that shows how many trees you're going to put in, the curbing, and all the nitty-gritty detail that the developer is going to build into that site. That's what the site plan review is. A site plan review is not the beginning, it's more towards the end. Okay. So here's where we are with Ted's application. He made an application for site plan review. We take what people give us and we go from there. So that was his decision. I totally agree with you. I think it's insane.
Yeah.
To have a site plan review for pier.
Yeah.
And what we need to do, you know, but the site plan review is what we apply in a non-residential context.
Right.
And it talks about structures, so, you know,
The
you
core
can
of
do that.
our disagreement was not that, because we didn't vote as a board on how to handle it. I thought we'd had consensus to treat it as a peer permit. We didn't vote. So when John says we're gonna treat it as site plan review, I'm not arguing with that. The particular disagreement that John and I had was that, okay, well, now we're gonna have to have Ted come back to us after he gets site plan review approval with a peer permit application and charge him $175, which I don't wanna do. But if we are gonna follow our process and he's gonna do site plan review and we're gonna treat the permitting separately, that would be the right process. John disagreed with that. He thought we just charge him the $100 and we give him a peer permit. And that doesn't seem right to me. Like, if Ted wants to do it this hard way, do it the hard way. I'm sorry, Ted, I wish you wouldn't do it this way. I don't want to charge you $275, but if you're gonna break it up like this and do site plan review for every step of your development, then site plan review is $100 and the peer permit application is $175. I'm a stickler for having a consistent process and following it, whether trying to separate that from how much I like the person and how easy I want it to be for them, which I do for Ted, but we have to be clear about this, or we're gonna get tangled up later on. And I'm just worried that we're not clear on it.
Well, you know, I shared with you my view on it, and again, I don't think it's, I think we're close together. My concern is the same as your concern. I don't think you should pay twice for the same thing. There's absolutely zero, from my perspective, of the criteria in the site plan review that apply to the putting in a pier, right? You know, there may be something, but we're all very familiar with the pier process. And again, I think it would be helpful if we looked at an amendment to that ordinance to make it clear that this kind of situation doesn't happen again, that you don't need to even look at the site plan review ordinance if you're just putting in a pier. But that's what he decided to do. He decided to make the site plan review application. And so what do we do with that? Again, in the context of the site plan review process, it is a subset of getting the pier permit in this context, right? It doesn't make any sense, and we could easily say that it seems, I mean, this is my opinion, we could easily say that the criteria of the site plan review don't apply. We're not spending any more money in order to process the site plan review.
So Ted gets to do a peer permit application for $100, while everybody else who does a peer permit application has to pay $175 because he's calling it site plan review.
He still has to comply. You flipped it.
I did.
You
Tricky like that.
Well, let's untrick it. Let's stop being tricky. If the permit that he's obtaining is for the pier, that's what he pays for. He doesn't have to pay for the site plan review because there is nothing going on with respect to the site plan review. Because I asked the attorney this. I said, because you know,
Then he owes us $75.
That's the issue. And he said, well, and I said, why would you pay twice for doing the same thing? And he said, well, in so many words, if you're doing work related to the site plan review process, then there's a cost for that. But if we're not doing any work with that because the criteria don't apply, then there's no charge. But anyway, we're splitting hairs, perhaps. I'm losing everybody.
At the time of this original site plan review, we explained that giving us a comprehensive plan, site plan for what activity was supposed to be immediately done was to be presented, it would be easier at the original site plan hearing when we went to do the site visit and everything.
Yeah,
That's where we walked.
For the second, for that second layer there.
Right, correct. I'm talking about when we did a site plan review ordinance hearing on site.
Right.
With the abutters present. And that was their chance, the abutters' chance to see everything that was going on, including, at that point, a pier wasn't presented, am I wrong?
That's right, it was just limited to that
It
one
was-
section.
It was
Right.
mentioned, but not really presented.
It wasn't presented, it wasn't in the plan.
Mhm.
So it wasn't. And the reason why we're doing a site plan review ordinance. Is that it's commercial activity, so anytime, any commercial. Property. And commercial changes. Anything. It's in our ordinance that we're to do another site plan review. Correct?
Well,
I don't think
It's-
so. I don't.
Or is there like a? I mean, that's.
Gary, I think you want to say something. Go ahead, Gary.
So I think what you're missing, what this conversation is missing is, in the case of Sheepshead River Marine, the pier is not the reason for the site plan review. It's the use of the pier.
Mhm.
So in my mind, as April was saying, Ted came in with a pier permit application for a commercial use. So the pier permit application is 175. On top of that, because it's commercial use, there's a site plan review in addition. So there should have been, in my mind, in my view, 275 permit application, site plan review fee, and then you would look at the whole thing together. And the reason he's doing that is because, when he initially came, he didn't have DEP approval for
Right.
his pier.
Yeah.
And you guys require DEP approval to hear a pier permit application. So that's why he chose to break it up.
Okay,
Right, if he had done it all at once in December, if he'd had pictures of the pier and was ready to go forward with that. I don't think we would have to do another site plan review now that he submits the application,
We
because
have-
we did it,
We
but.
have approved pier permits pending DEP approval before as well.
yeah, but no, I mean, all right, but where do you go with that? You're saying that.
I was
there's no
just
site plan.
addressing Demi's statement about anytime a commercial activity happens, we do site plan review. That's true, but I believe the way I read site plan review is an applicant can bundle those things. So if Ted was like, I wanna do 3 parking lots, a pier and a building, he told us all about it. And we gave him the thumbs up with the vision, he could just go ahead and get the permits through
Right.
Barry, through whoever.
Yeah, but he didn't do that.
Let me read a little bit
Yeah.
from the ordinance.
Yeah.
So this is the applicability section. So it's the very beginning. So it says all town of Westport Island ordinances and regulations apply as appropriate and relevant to any project covered by this site plan review ordinance. Whenever the provision of this ordinance conflicts with or is inconsistent with another provision of an ordinance, the more restrictive provision shall be controlled. So that's the standard, whatever is more restrictive if the ordinances don't say the same thing. That's 3A. 3B, a person who has right, title, or interest in a parcel of land must obtain site plan approval and, where appropriate, subdivision ordinance approval prior to commencing any of the following activities on the parcel. So it's up front before you go and get the building permit to build that structure. And that lists the number of things: obtaining building or plumbing permits, construction or placement of any new building, expansion or relocation of existing non-residential buildings, expansion of existing non-residential use. So there is a point to be made if when we approve a site plan review and it doesn't include the activity now being added, that they have to go through it again.
Right, it's a site plan revision.
Yes.
And there's a whole
We can
section
talk
on
about that.
site plan
Yeah.
revision, so what Ted's probably really trying to do is a site plan revision. So we can look at that, but I believe afterwards he has to do, and he's probably expecting this, cause I think this is what he did last time, he did site plan. And then he went and got permits normally, right, Gary? I mean, just through the normal channels?
It can be done either way. I mean, site plan can be done in advance, just with a plan.
Mhm.
And then the permitting can come afterwards.
Yeah, because I mean, when we were out there and we were talking about this, we just talked generally about what else he was planning to do. And he said, I'm not applying for that now. And so he drew the line in the sand,
Right.
so.
Yeah,
I
Right.
think we weren't very clear in terms of how we present what this is
Yeah.
about.
Yeah.
But I think actually kind of going back to the front end, it tells me this is kind of the early stage. You have a business deal you want to do, you want to do something with the property. You plan out what you want to do.
Yeah.
And you may decide not to do some of
Right.
that. That's
Right.
okay.
Right.
But at least we agree, yes, this is gonna be commercial.
But I think, again, going back to our major project this year, I think this is an opportunity to clarify all of this so that we don't step in this again.
Right.
And with respect to everything we've talked about Ted's, I gave Ted notice that we're here. Again, we're not making any decisions tonight. We'll raise it on the 8th. And
maybe we should vote on how to treat it and
Not
have a
tonight, we're
discussion,
not
not
taking any
tonight, no,
vote.
no, I
No,
mean
no.
at the next meeting, but just so we
That's-
can speak with one voice.
that's
to
what I'm
Ted.
saying. That's what I'm saying.
Yeah.
We've talked it through, we
Right.
brainstormed it. I'll put it on the agenda for the 8th and then we'll have any further discussion. We'll hear from Ted and any other members of the public, and then we'll make a decision about how we want to process it.
I have a just general question about hierarchy and order,
About what?
hierarchy and order.
Yeah.
My understanding was that PBR, planning board review, was to happen before issuing permits. Is that?
It depends on, you go to that, to our schedule of all the things and who approves them, so. We don't really approve much. I mean, most of that's Gary, but if something is scheduled for us to address, then yeah, we're part of that process. But we don't issue the permit. Gary does.
We don't issue the
Sometimes we
permit, but it's pending, the permits are pending upon planning board review.
Site plan review? Yeah,
Right.
Yeah, again, it's part of the process, right? I mean, at this, the end result is issuing the permit. How do we get there? If you're building a house, in a non-shoreland zone area, you don't have to
Yeah.
do a site plan.
Straight to Gary's.
You just
Yeah.
build a house. If you're building a commercial garage, that you're going to be servicing cars in a business, that falls into a different
So-
category, and you need a site plan
The only
review.
reason I'm asking this question is because when we usually receive peer permits,
Mhm.
there is an application, there's a permit that's attached to it from
Right,
a bill,
right.
So
Yeah,
that's not
we sign off on that, and the select board does.
right, and they're just doing that to expedite the process, but that's not necessary.
it is necessary. It's not site, so a peer permit application has nothing to do with site plan review unless it
Mhm.
happens to be a commercial developer. So when we get peer permit applications, normally, we're just the permitting authority. If you look at the table of land uses, for some reason, the planning board gets permanent peer ramps floats. So we're Gary in that situation.
Yeah.
We're just permitting.
Yeah.
And it requires select board sign off, planning board sign off, and then Gary does the administration of giving the permit number and actually getting it to the applicant.
That's basically, is that the only time? I think that's the only time that we issue the
But the
permit card.
plan,
I think there's others, but we've only seen peers, but if you look at the table, there's a few different random scenarios where the planning board gets pulled in,
Right,
especially in resource protection. The planning board ends up like houses, I think,
In that district, yeah.
in that
Yeah.
district, but it almost never happens.
Right.
So we mostly see
Relocating
peers.
Non-conforming structures,
yeah.
Yeah,
there are a few things, but mainly it's commercial, non-residential use and anything beyond the high tide line.
yeah,
I have a
Okay.
small process
good
question.
conversation, yeah.
I
go
have
ahead.
small process questions. So I've been traveling the last few days visiting the next generation of my family, so I may have missed something and I give John a lot of credit for all the communications he's doing. I would like to know as a planning board member, the communications that we've received from attorneys. So you've been talking to an attorney. I would like to know a tiny bit about what that's about, because
Yeah.
we're all planning board members, so,
Totally.
every time an attorney talks to you and you share with us, I feel very smart. So I would just encourage you to think about, that process, so that we're privy to the wisdom.
I am with you 1,000%, because I had the same feeling whenever I was sitting in your seat. And
Okay,
I heard about these conversations with the attorneys, because I think we should all be a part of that.
okay,
The, what happened here was, you know, we had a time crunch, and, April talked to the attorney, and I said, well, now I've got some questions, so
Oh,
I talked to the attorney.
yeah, when you get an attorney, I appreciate that,
Yeah.
that's a window of
Yeah.
time.
It's the MMA, not our town attorney.
Yeah. No.
So, and I'm just trying to figure out what to do with the check, but I'm happy to share that with you, Mary Ellen, if John is okay with me sharing our back and
Well,
forth.
I think you understand the
Yeah.
gist of what I'm asking.
Yeah.
With you 1,000%.
I think all the planning board would feel much, you know,
Yes, I'm with you 1,000%, and,
you're gonna share the chat.
I will, yeah, I'll share it with you.
the awkward part about that, and I suggested when I talked, or when I called the attorney, I said, you know, my first suggestion was, you know, we'd love to have you attend the meeting tonight, so we could hear him and you guys could
Yeah,
hear him
okay.
directly. But he called me right away, and so then we started talking.
Yeah.
So anyway, so I'm with you 1,000% and totally agree, because I feel very comfortable. And with respect to the Verizon, since everybody's lawyering up on this application, we need to have direct contact with that attorney.
With a town attorney.
With the town
Okay.
attorney.
Mhm.
And just to kind of warm you up to that, right? When that happens, we will be the client.
Mhm, mhm, mhm.
We,
Can I just say that the attorney did call me today, or we did have a conversation, our attorney, our town attorney. And we are gonna plan a meeting, and we will definitely invite the planning board and the select board. And hopefully that will happen in the next little bit, because the two of them had a conversation and he wanted, just to give us a heads up. So whenever we have that conversation, it may be at one of our Wednesday workshops, we'll definitely let you know, and whoever can attend.
Okay.
But we definitely want the planning board involved in that, but, this just came about today.
Okay, okay, thank you,
So,
thank you.
yeah,
yeah, and just to kind of warm everyone up, and I'm sure we'll have this conversation again too. The attorney-client relationship and the attorney-client communications are special things.
Sure.
As you all can imagine, if you all haven't had the
We try to
pleasure.
avoid attorneys, but yes, I understand. what
Yeah,
you're
yeah,
saying.
I had the pleasure before. So in that context, whenever we're having a conversation with the attorney, there's an expectation that that will be a privileged conversation.
Absolutely, I
Uh,
understand that.
You know, we won't go talking to other folks about it. And
although our meeting, when we do that, will be an open meeting, all of our select board workshops.
Yeah, we could
Well,
talk about executive
there's an
session.
executive,
Yeah.
That might be appropriate.
Yeah.
Yes,
if that's appropriate.
Yes,
If it's
the same.
appropriate, if it's.
Yeah.
Right, we
Well,
have to,
Okay.
let's be clear about it. Not only is it appropriate, it's absolutely necessary. We are not going to go forward talking to an attorney with the anticipation of litigation unless it's an executive session, and that's an exception, a statutory exception to the open meeting rule. So that happens all the time. And fortunately, we don't have a lot of experience with that here, because we don't get sued as a planning board, but we need to be very clear about that.
Yeah.
Meeting is not about litigation, and we have not, we're. From our perspective as a select board, that has not come up. But we do wanna talk to the attorney about making sure that we all are on the same page with. For example, some of these processes that we're
Sure.
using and whatnot, so they're twofold, but. Yes, if it's about the Verizon, it would be a different conversation than
Right.
the other
Okay.
conversation.
Okay.
they have.
Yeah, and I would expect our attorney, that'll be one of the first things he talks to us about is, you know, the conversation with him, if it's appropriate, be held in executive session.
Yeah, he will let us know.
So,
Can I just say, this janky laptop, the power cord broke at town meeting and I'm very low on battery. So I just want everyone to be aware of that. The Zoom might drop at any moment. And I'm sitting here, I feel like we're wrapping up, but I just want that to be effective.
well, it's 7:30, so I think it's an appropriate time. But at any rate, anybody else have any? Gary, thank you very much. Appreciate your help. Anybody else have any comments? For members of the public, again, this wasn't a public hearing kind of thing, but does anybody have any questions, concerns? Before we leave it? Okay. All right, well, this was
Mr.
good.
Chairman, I just wanted to ask, we're sending 8 copies, hard copies that were FedEx out today. Is that sufficient or would you like more? Because it is pretty voluminous and I just want to make sure that you're not burdened with having to make the extra copies. If you'd like more, we're happy to supply more.
Mr. Berghoff, I think send us as many as you feel comfortable, because they're gonna be members of the public
Okay.
who are gonna have a difficult time dealing with it in a digital format, so I don't want to break the bank.
Did you ask Dick's question about making the prints 11 by 17?
I can do that. Anything. The site plans are going to be it's 11 by 17 attached to the hard copy, but then we also submit full size. I think it's 24 by 36, so you can really spread them out. And I'll send. We usually just send a couple of those copies because they're. But I'm happy to send as many as you want. I think there's probably 8 hard copies of the packet, and then probably 4 or 5 copies of the site plan. But if there's anything more you want, just let us know, and we will. I'll just have my secretary send more.
Yeah, I should put the digital version on the website somewhere. So if members of the public want to view it.
Like there's one for the town at least and one for each of us.
Yeah,
To just be attached to the meeting minutes as an exhibit.
yeah. One,
Select board want any?
Yes, each of the select board was.
So there'd be 3 more there.
Yeah.
okay, so
For the town records, 4.
I think I'm not, my abacus isn't working
Come on, John.
really well, but I think we're up to about
12.
12.
Let's go 12.
Let's say 15, just to
Okay,
be
great.
safe.
Okay.
Okay.
Eight were FedExed out today. How about I put another 8 in tomorrow or the day after?
Yeah, that sounds great.
Thank you.
Nice.
Thank you very much.
Yep. You
And-
bet.
It's gonna be happy.
And while we've got you on the speaker here before we lose power, have you all had any thoughts or consideration about initiating a meeting with the town and looking at alternative sites?
Yes, we're happy to do that. And let me also mention that before I hit that I did call the fire chief as was requested and spoke with him. And he said they do have a need for a repeater. They tried to go on the existing 294-foot tower. It failed. I'm not sure why, either structurally or permission was denied. But I told him that we are more than welcome to have him put a repeater on our tower at no cost to the municipality. He said we'd have his RF engineer look at it and get back to us with what their needs might be. And I'm sorry, as to alternate sites, your first question. Yes, we are looking at 1 or 2 others, but this is the kind of thing where at the public hearing or even before, direction from the town is helpful. Again, as I said before, we don't care where we go as long as it works. And there are 2 other people who have approached us. And so we're doing some RF testing to see whether or not those sites would work. And if they're interested in, engage, it's obviously got to be available. They have to be interested in engaging in a lease. We'd like to present as many viable options as possible because again, we want to be where the town would be most favorable to the town. And we don't care where that is.
Okay, we're because we haven't advertised the subject matter of this current conversation, and the public isn't able to participate right now because they don't know about it. I'm going to ask you and us to repeat this conversation at our next meeting.
Mm-hmm.
And what if you could give some thought to, and this is just my idea, and again, we'll defer to the board on the 8th, but if you could give some thought to the first meeting being just a show and tell, here's what we're all about and here's what we're proposing, and maybe inviting conversation about alternative sites and interests. But at any rate, as broad as you feel comfortable making it as the first meeting before we get into the details, because I really think it'll go a long way to addressing whatever anxiety there is in the community. If you have an opportunity to have a very honest exchange, give and take with the community about this, so they don't feel like this is something being done to them, as opposed to you're doing your business and perhaps also solving a problem for the island. So we want to start off on as positive a note as possible, and by being as inclusive and open to the community input at the first meeting, I think would be really helpful. So again, we're not making any decisions. We'll have this conversation again on the 8th, but since we're talking and you're here, wanted to give you an opportunity to start thinking about it.
No, I appreciate that. The one thing I would mention to the community in the town now is in the materials is the search area. That search area, so people can be thinking about alternate sites. It's got to be in or around that search area. It's pretty broad, but that's a good guide for people. And beyond that, I just want to say that I appreciate the thoughtfulness this municipality is putting into this application, this process.
Yeah, we wouldn't be having this meeting if we didn't care, and we care about what you're trying to do as much as we care about the residents' concerns. So I think working together will get to a good place.
I agree.
All right. Anybody else have anything else to say? All right. Thank you all. Thanks for your time. Thank you for the great conversation. I love you all, and I appreciate you all.